To OPR's CEQA 202 series, this time discussing standards of review. My name is Natalie Kuffel, and I'm the Land Use Counsel at the Governor's Office of Planning and Research, and I'll be moderating today's discussion. I'm joined by Shannon Clark, who is a recent addition to OPR's legal and legislative team. She joins us from the Attorney General's office and will be our new land use counsel. So she'll be presenting today. We're also very pleased to have two special guests joining us for today's discussion. They are both attorneys with multiple years of experience in CEQA and land use law. First, we'll have Sabrina Teller, who's a managing partner at Remy Moose Manley. And we'll also have Matt Kiesling, an attorney at Taylor & Wiley, joining us. Thank you so much, Sabrina and Matt. We're pleased to have you as part of our discussion today. And we're also receiving technical assistance today by Mitchell Iwahiro, a special assistant here at OPR. All right, next slide, please. So just as a reminder, OPR has been producing a series of webinars that we're calling CEQA 202. These go a little more in depth than your typical CEQA 101 overviews on specific topics. So far, we've produced two webinars before this one. The first one was on how to determine if an activity is a project under CEQA, and the second was on exemptions. Both are available on OPR's YouTube channel and on our website under the CEQA overview tab. Right, next slide, please. So just a little bit of housekeeping for today's webinar. We will be using the Q&A function at the bottom of your screen, not the chat function. So if any questions come up during the presentation, please input those using the Q&A function. There will be a designated time at the end of this presentation where we will answer the questions. And if you see that a question's already been asked that you would like to ask as well, there is a function similar to upvoting where you can kind of thumb up that comment and it will move to the top of the queue. And that's how we know that that is a question that we should ask with a lot of interest. And those questions will likely be the first ones asked at the end. So you'll also see we may be answering questions as it goes along using the chat function within the Q&A, so answering them and moving them off to the side. So if questions disappear, you can find them in the answered section there. All right, next slide. Perfect. So I will be handing this over to Shannon to kick us off discussing what are legal standards of review.
Thanks, Natalie. So in short, a standard of review is defined as the amount of deference a court gives a public agency in reviewing its decision, or the amount of deference an appellate court will give a trial court's decision. So for example, under a highly deferential standard of review, a court will scrutinize a decision less closely and a higher burden will be placed on a party trying to overturn that decision. So in general, the more deference that is afforded under a standard of review, the less burden is placed on an agency to defend its decision in court. So that brings us to what are the standards of review used in CEQA cases. So under CEQA, a court's review is limited to considering whether an agency committed a prejudicial abuse of discretion. And as we'll discuss in the next slide, there are two ways to demonstrate a prejudicial abuse of discretion, and that leads to two corresponding standards of review, de novo review and substantial evidence review. Within substantial evidence review, there's a subset standard of review called fair argument standard, which differs in important ways, and we'll discuss that in detail as we go forward. So prejudicial abuse of discretion. CEQA states that an abuse of discretion is established if, one, the agency has not proceeded in a manner required by law, and this is typically reviewed under de novo review, or two, its determination is not supported by substantial evidence. And unsurprisingly, this is reviewed under substantial evidence review. So let's just briefly talk about what each of these standards mean. So the first is de novo review. And under de novo review, no deference is accorded to the agency's decision. So instead, the court will scrupulously enforce all legislatively mandated CEQA requirements. So under de novo review, a court is not going to defer to an agency's decision to follow procedures in a certain way. Instead, the court is going to closely examine the actions that were taken by the agency and determine whether those actions comply with CEQA's requirements. And that brings us to substantial evidence review. So unlike de novo review, substantial evidence review is deferential to the agency's decisions. So under the CEQA guidelines, the substantial evidence is defined as enough relevant information and reasonable inferences from this information that a fair argument can be made to support a conclusion, even though other conclusions might also be reached. So under substantial evidence review, the court does not evaluate the correctness of the conclusions in the environmental documents. The court does not weigh conflicting evidence and determine who has the better argument. A court solely looks at the sufficiency of the evidence supporting that agency's conclusions. So, under substantial evidence, if an agency has reached a conclusion and evidence exists supporting a fair argument to support that conclusion, the court must defer to the agency's conclusion. And that is true even if other evidence exists that supports an opposite conclusion. So long as substantial evidence exists supporting the agency's conclusion, the court will defer to that conclusion. So this turns us to fair argument. As I mentioned, it's a subset of substantial evidence, but what you'll find is that what it really does is kind of turn substantial evidence on its head. So a fair argument is a low threshold test for anyone challenging an agency's decision in court. So unlike traditional substantial evidence, the courts don't owe any deference to the agency's determination. So the CEQA guidelines provide a definition of fair argument standard as it relates to whether or not a lead agency shall prepare an EIR. And Sabrina is going to go into detail later on in the presentation as to how and when fair argument standard is used. But for now, we'll just review that definition in the CEQA guidelines. So if a lead agency is presented with a fair argument that a project may have a significant effect on the environment, the lead agency shall prepare an EIR, even though it may also be presented with other substantial evidence that the project will not have a significant effect. So in contrast to substantial evidence, under the fair argument standard, if there is any fair argument that a project may have a significant effect on the environment, the lead agency shall prepare an EIR. And the court will not defer to an agency's decision-making in that regard. So this actually brings us to our first poll question, and I will turn it back to Natalie to lead us in that.
Thank you so much, Janet. So as you'll see, we have a few polls interspersed throughout the presentation just to make sure you are paying attention and give you something fun to do. So the first question is, launch it for you. Can personal observations that a proposed project would be aesthetically inconsistent with the surrounding neighborhood constitute a fair argument that the project would have an adverse aesthetic impact? Yes or no? I have just a little bit of time for people to vote. Go ahead and end the poll. And I will share the results. This is very interesting. We have almost a 50-50 split here. 52% of those who participated said yes, that those neighborhood observations about aesthetic inconsistency would constitute a fair argument, and 48% said no. All right. And the results are, next slide, please. Or the correct answer. Yes, that would be enough to constitute a fair argument. And this fact pattern was actually taken from a case, Protect Niles versus the city of Fremont. And we'll hear more about fair argument later on. Go ahead, Sabrina and Matt.
Great. Thank you, Natalie. So the question then becomes, when do we apply the standard of review, and when does a court apply the various standards of review to agency determinations? The first ones we're going to cover, it sounds like from the last two OPR webinars, people are aware that the initial question when it comes down to CEQA review is whether the activity itself is even subject to CEQA, and then whether the activity falls within a CEQA exemption. There are both statutory and categorical exemptions to CEQA. And the first one I'd like to touch on is, what is the standard of review when it comes to statutory exemptions? In the context of statutory exemptions, which are found at Public Resources Code 21080, first thing that the court does is it conducts a de novo review of the statutory exemption itself to find out whether the agency had interpreted the exemption appropriately, and whether the legislative intent behind the exemption was actually being followed appropriately by the lead agency. If it finds that, in fact, that has occurred, the next step would be, did substantial evidence support the lead agency's determination that the project fell within the scope of that claimed exemption? So, as was explained by Shannon earlier, as long as the exemption was interpreted appropriately by the lead agency, which the court looks at from a de novo perspective, great deference is afforded to the locality's decision whether or not the project falls within the scope of that statutory exemption. And those two steps are really the beginning and end of the standard of review for statutory exemptions. And in my experience, judicial review of statutory exemptions tends to be somewhat clear-cut. Interestingly, as was noted in the Sunset Sky Ranch versus County of Sacramento case, there the Supreme Court said that the legislature specifically exempted certain activities from environmental review, and these exemptions reflect legislative policy decisions. Although we construe CEQA broadly to afford the fullest possible protection to the environment within the reasonable scope of the statutory language, we do not balance the policies served by the statutory exemptions against the goals of environmental protection. So effectively, if the court finds that the exemption exists and has been interpreted appropriately, it defers to the locality's determination whether that the project falls within it, and it will uphold the agency's determination. Next slide, please. The standard of review for categorical exemptions is pretty much the same as it is for statutory exemptions, except it requires an additional step that becomes a little bit murky. So for background purposes, and it seems that you know from prior webinars, that categorical exemptions have been directed by the legislature, but established through the Secretary of the Resource Agency to promulgate a list of a class of projects that are presumed not to have a significant environmental effect. However, there are 6 exceptions that can be asserted against utilization of a categorical exemption. And if that occurs, the courts need to look at the agency's determination of whether the exception applied or not. Exceptions fall in a variety of areas, but the exceptions to utilization of a categorical exemption would be something along the lines of whether the specific project site was in an environmentally sensitive area, or whether a project site has been identified to be have a hazardous substance or needing to have hazardous cleanup on the site, which would then remove it and effectively negate the categorical exemption. So in looking at utilization of categorical exemptions, the standard of review that a court applies is first, once again, the de novo review to look at the categorical exemption and to determine whether the agency had appropriately interpreted the exemption and its various component parts. The court then would apply a substantial evidence standard of review to the locality's decision that a project fell within the scope of that categorical exemption. And then the next additional step that the court would do is that it would look at the agency's decision of whether an exception applies, and they afford that decision a deferential standard of review as well. I will say there are sort of two caveats to exemptions as a whole. One is for the common sense exemption, and that is that if you try to approve a project based upon the common sense exemption, the courts apply a fair argument standard of review to the common sense exemption. And if there has been a fair argument that the activity could result in significant environmental impacts, then the agency should have used some form of review more than utilizing the common sense exemption, and it will be overturned. Additionally, in the context of the unusual circumstances exception, the court has actually laid out a two-pronged analysis, which requires two different standards of review that we'll touch on later. Now I'll pass it to Sabrina for negative declarations.
Thanks, Matt. So as Shannon touched on, when we're dealing with negative declarations, the substantial evidence standard gets flipped on its head, and it's an easily rebuttable presumption. So as a matter of law, an EIR is required whenever it can be fairly argued on the basis of substantial evidence that a project may have a significant effect on the environment. And that's, of course, derived from the language of those statute sections, and it's enshrined in guidelines section 15064F1. The courts have explained that may means a reasonable possibility, not, of course, a certainty or a shall or a will. And the fair argument review that a court undertakes is based on reviewing the entire record before the agency, not just the contents of an initial study or written comments that might be received on that review, but any scrap of paper that is in the record is potentially a source of substantial evidence to support a fair argument. Next slide. So the fair argument, as you've heard it described, is a very low threshold. My partner, Whit Manley, likes to liken it to stepping over a garden hose, which may be a little too obvious, but it's pretty apt in trying to convey the ease with which it is possible to make a fair argument challenging a negative declaration. The Stanislaw Audubon Society decision in 1995 held that the fair argument standard is a low threshold test, and that an agency should not give an unreasonable definition to substantial evidence, you should not equate it with overwhelming or overpowering evidence, as CEQA does not impose such a monumental burden on those seeking to raise a fair argument of impacts. And substantial evidence, of course, is defined in the statute and guidelines as facts, reasonable assumptions based on facts, or expert opinions predicated on facts. It is not argument, speculation, inaccurate information, unsubstantiated opinion, or social or economic impacts unrelated to environmental impacts. These definitions apply to evidence considered to support a fair argument. The courts have reiterated over the years that project opponents need not necessarily be experts to provide substantial evidence supporting a fair argument and forcing an EIR to be prepared. For many topics, especially non-technical ones, lay opinion, lay testimony based on relevant experience or observations is entirely sufficient. For other types of more technical issues, however, the courts have disqualified lay evidence occasionally as not substantial. For example, on issues of aesthetic significance particularly, several courts have determined lay commenters' opinions about the compatibility and consistency of a proposed project's design with their existing neighborhoods to qualify as substantial evidence supporting a fair argument. In others, courts have discounted lay comments on issues like wildfire evacuation plans or technical traffic impacts as lacking a necessary expert foundation or credibility to qualify as substantial evidence. Substantial evidence supporting a fair argument of any potentially significant environmental impact triggers the preparation of an EIR, regardless of whether the record contains contrary evidence. Under this unique test, the courts have held that deference to the agency's determination is not appropriate, and its decision not to require an EIR can only be upheld where there's no credible evidence to the contrary. And so for that reason, you would necessarily assume that when you're preparing a negative declaration and you get any kind of even somewhat sophisticated comment or opposition to it, the agency ought to start thinking hard about preparing an EIR. Next slide, please. So this lack of deference extends even to issues on which agencies are usually afforded deference because of their presumed expertise. So for example, in interpreting their own plans, policies, and ordinances. So for an inconsistency claim arising under the planning and zoning law, for example, the agency would be afforded substantial deference to its interpretation of its own plan or policy, as long as it's a reasonable one. But when we put the CEQA hat on, in Pocket Protectors, Protect Niles, Georgetown Preservation Society, all those courts held that where opponents had asserted that proposed projects were not consistent in some respect with applicable plans or zoning for the proposed project sites, those assertions qualified as substantial evidence supporting a fair argument of potential impacts arising from an inconsistency with a plan, policy, or ordinance adopted to protect the environment. Now, notably, in those cases, there wasn't always clear evidence in the record, or at least not stated in the opinions, that the plans and policies at issue were adopted expressly as mitigation or were connected to avoiding some environmental impact. It seems through those courts' opinions that it was enough that they were just sort of environmental in nature. So when plan consistency claims are invoked in the context of CEQA, challenging specifically the adoption of a negative declaration, that traditional deference to the agency's interpretation of its own plans goes away and the fair argument prevails. Next slide. So moving on to the slightly more complicated realm of assessing the viability of environmental impact reports. As Shannon touched on, the fundamental question in front of a court in any CEQA claim is whether the agency has abused its discretion. And the court is reviewing the record of a project for which an EIR is prepared not as a fact finder, but to determine whether there has been a prejudicial abuse of discretion. And as we've explained and highlighted before, that standard involves two inquiries: whether the agency failed to proceed in the manner required by law, and whether the agency's record contains substantial evidence supporting its findings and decision. So we'll talk about those standards in a little bit more detail in a moment, but in a nutshell, allegations of compliance with a procedural requirement to review de novo factual issues are considered under the substantial evidence standard, under which the court tries to be deferential to the agency's factual determinations and other matters within the agency's expertise. So the court puts on a different standard of review hat depending on what type of claim a petition alleges, or multiple claims. But it's not always very easy to determine which standard applies to, say, a particularly novel or nuanced claim. Next slide.
All right, looks like it's time for our second poll question. And I will launch that now so you guys can start submitting your answers while we read it out. So the question is, if a discussion of an environmental impact in an EIR lacks analysis of the impact or omits discussion of the magnitude of the impact, what standard of review should the court apply? And the options are A, substantial evidence, B, fair argument, or C, de novo review. So I'll give you another minute to submit your choices, and then we'll reveal the results and the correct answer. All right. End the poll there and share the results. So as you can see, once again, we have a split in what folks think the correct answer is. 56% of those who participated thought substantial evidence would be the appropriate standard of review. 28% thought de novo review was the appropriate answer, and 16% thought fair argument. So Shannon, please reveal what the correct answer is. Okay, so the correct answer is C, de novo review. And you can see this in the case Sierra Club v. County of Fresno about the Friant Ranch case, which I believe Sabrina will be discussing next. So I will hand it back to her.
Thank you, Natalie. So as we previewed in the poll question, some types of claims challenge the sufficiency of the EIR as an informational document. And of course, we all remember that the purpose of CEQA is supposed to be an informational function at heart. And so when claims are framed as the type of flaw that gets to the sufficiency of the EIR as the informational document that it is intended to serve, then the court may switch to a de novo standard of review. So let me give you a little bit of background on the Sierra Club versus Fresno County case, also known as the Bryant Ranch decision. One of the claims in this case challenging a new subdivision in Fresno County was that the EIR had failed to consider and disclose the potential health effects of air pollution that would result from the construction and operation of the project. The EIR had disclosed and determined the air quality impacts to be significant, had disclosed the emission, the raw emission levels, and had considered those air quality impacts as significant and unavoidable, and acknowledged generally in the air quality discussion that air pollutants can cause and exacerbate health effects, but it didn't attempt to connect the project emission levels to any specific health effect on area residents. And that was a claim the petitioners asserted was required in the CIR. And so prior to this decision, parties had routinely disputed which standard of review applies to this type of claim, essentially attacking the depth or extent of analysis of a particular issue. So petitioners would allege that a CEQA violation has occurred and that this violation constitutes a failure to proceed in the manner required by law. A respondent would argue that this same alleged violation is reviewed under the substantial evidence standard of review. And resolving this dispute was important because each prong of the standard of review, of course, affects the amount of deference that a court pays to the agency's record. So in Bryant Ranch, by the time it made it up to the Supreme Court focused on the extent to which the EIR's discussion fulfilled its informational role for decision makers and the public. The court emphasized this informational function and found that this EIR failed to fulfill this function on this issue. And so there's some choice quotes there from the court's opinion. Next slide. So the court resolved this dispute by pulling more of these types of claims into the de novo realm, saying that claims that an EIR lacks analysis of an issue, here the connection between health effects and air pollution, or that it fails to discuss the magnitude of the impact, that those are mixed questions of fact and law to which the de novo standard should apply. The court acknowledged that as to claims based solely on factual determinations, such as an agency's choice of methodologies to apply, the substantial evidence standard would continue to apply. Ultimately, again, the court's reviewing task is to determine for itself whether the EIR fulfills its function as an informational document. And so, notwithstanding the court's attempt to resolve this longstanding dispute about the standard of review, in my experience since the issuance of this decision, that debate continues in the CEQA realm, with petitioners citing Bryant Ranch to assert that all of their claims amount to allegations of a failure to fulfill the informational function, and thereby try to get the de novo standard. And in contrast, the respondents are arguing, no, these are more like factual determinations. And so ultimately the court has to decide where on this spectrum those types of claims land. And it's still not always clear to me where they properly belong, but we do our best. Next slide. So now that we've tried to explain how the courts address some of the gray areas, it's a little easier to cover the types of issues that are squarely in the de novo standard of review. Claims that are clearly based on mandatory procedures under CEQA, such as whether an EIR has omitted a required discussion of alternatives or if it's illegally approved a project before it's prepared in the environmental review. Those are all still reviewed de novo. The courts have reiterated that such procedural requirements are to be scrupulously enforced, and therefore little to no deference is given to an agency's determination on such issues. Next slide. The poll.
All right, that takes us to our third and final poll that I will release now. And the question is, in determining whether an EIR should be recirculated, what standard of review should apply? A, substantial evidence, B, fair argument, or C, de novo? Give you another minute to participate. You'll see in the Q&A, we have a lot of questions about the poll questions, which is not surprising. Right, looks like we've got to 60%, so we'll end the poll and share the results. So here, 58% thought that substantial evidence would be the appropriate standard for recirculation. 23% thought de novo, and 19% thought fair argument. So Shannon, please reveal the answer. It is A, substantial evidence. And this comes from the Laurel Heights decision. We'll discuss that more in the next slide.
All right, so back in the realm most comfortable for respondent agencies, the substantial evidence standard. Of course, in contrast to the de novo standard, the substantial evidence standard is highly deferential to the respondent agency. A court looks for any substantial evidence in the record to support an agency's factual determinations and must uphold them if there is such evidence, even if other conclusions could have been reached. An agency's determination of issues like the significance of an impact, the choice of methodology, the effectiveness of mitigation measures, the proper geographic scope for analysis for certain impacts, whether recirculation is required before certification of a final EIR, or whether alternatives would have greater or lesser impacts, or whether they're infeasible. These are almost always going to be substantial evidence questions. I think the poll question and the results indicated probably still that some of these questions, some of these issues are not necessarily immediately intuitive as to which standard would apply. So I'm going to touch briefly on the recirculation question and explain why that's substantial evidence. And that is because the way that the recirculation question is framed, it is whether there has been an addition of significant new information. And the agency has to determine whether that addition has been significant, whether the amount of change in the document, whether the type of information added is so significant that it prompts recirculation, whether it meets that standard of significant new information. So that is inherently, according to the courts, a factual determination, and therefore that's why it's in the substantial evidence realm. And similarly with all of these other, with most of these other types of issues, once you peel back the layers, it becomes a little bit more apparent why those are in the substantial evidence standard, and it's because of their connection to the factual determinations that the agencies are tasked with making. In all types of litigation, but especially in the substantial evidence standard, a petitioner still bears the burden of showing that a respondent agency has failed in some regard, but under the substantial evidence standard, they have to show that it has no substantial evidence to support its determinations in these types of claims. And obviously showing no evidence is a high bar, and it's why those types of questions are frequently hard for petitioners to prevail on unless the agency has made an egregious error somewhere. I will turn it back to Matt to take us on to special topics.
Thanks, Sabrina. So there are three special situations we wanted to touch on today as well, where really there has been recent court decisions clarifying what the standard of review would be, and they're somewhat unique to these particular fact patterns and types of cases. The first one would be in the case of subsequent review of a project. The next one in the utilization of the unusual circumstances exception to a categorical exemption. And the third in the somewhat new environmental document, Sustainable Communities Environmental Assessment. Next slide, please, Shannon. So in the context of subsequent review, I think as most people know, once a project is approved pursuant to CEQA analysis and that analysis has been certified, Often over the course of a build out of a project becomes modified or changes in some way given market conditions, change of ownership, any number of reasons why a project would be modified. Assuming that that modification to the project requires you to go back to the lead agency for an approval, it would then become subject to CEQA once again. And the lead agency is then in a position of having to make a determination as to whether to allow that modification to the project to tier off of the previous environmental document or whether it needs new environmental analysis done altogether because it's a new project. And for years, there had been a split between the courts as to whether the determination if a project was a new project or simply a modification to a previous project would be subject to a de novo standard of review, whether that determination was a legal determination subject to de novo review, or whether that was a factual determination, which was best left up to the local agencies and therefore afforded a substantial evidence standard of review. The Supreme Court in Friends of San Mateo Gardens resolved this issue and determined that substantial evidence is afforded to the decision of whether a revised project is new or simply a continuation of a previously approved project, meaning that now great deference is given to the locality, whether it will allow you to tier off of a prior environmental document or whether a new document needs to be developed. So I think as a result of San Mateo Gardens, you've seen agencies less reluctant to utilize subsequent supplemental and addendums in moving forward with modifications to projects. However, another question with respect to standard of review came up in the context of that case as well. And that was, if you decide to move forward with some sort of subsequent analysis, what standard of review is applied to that analysis? In the case of Friends of the College of San Mateo Gardens and San Mateo Community College District, the project, which was a decision to reconfigure one of the community colleges by demolishing certain buildings and rebuilding other structures, had been modified, and that certain buildings that had been slated for demolition were then reversed and other buildings were slated for demolition, but the project had originally been approved in reliance upon a negative declaration. So when that college came back through with modifications to that project, they sought to have it approved through an addendum to the mitigating neg deck. And what the court held is that the standard of review that is applied to the subsequent document would be consistent with the standard of review applied to the prior document, meaning that if you're an addendum to an EIR, you are afforded substantial evidence standard of review. And if you're an addendum to a negative declaration, you would be afforded only fair argument standard of review. And I'm happy to defer to Sabrina if she has anything else she'd like to add to that case, since she actually was the attorney that argued that.
Yeah, I'll just say, thanks, Matt. I'm glad I let you present that because it's hard for me to be objective about this case, but it was sort of a mixed bag for us because we won the question that we certified to the court, which was whether this new versus previously reviewed project should be a de novo standard of review. And in that respect, the court kind of returned the law to what it had been assumed to be before the 2006 decision of Save Our Neighborhood versus Lishman, where the third district for the first time sort of invented this de novo standard for this question of a new versus previously reviewed project. And then as a result of that decision, there had been a lot of uncertainty since 2006 as to what standard would apply, but then the court definitively resolved that that's a factual determination. On the second question about what standard of review should apply to the later document, or at least to an addendum, there was an argument that we made that didn't prevail, that because the previous negative declaration had passed the statute of limitations and thereby, according to the law, was presumed valid, presumed to have the conclusions in it correct, that it shouldn't be fair argument for that, because you're basically updating a document that has been deemed valid by operation of law. But the court disagreed and said, no, that standard persists because in part because there has not been this exhaustive analysis to which we afford the substantial evidence standard. So our argument did not prevail, and now at least the standards of review are fairly clear when it goes to subsequent review, unlike some of the questions that come up for EIRs and the standard of review in these sorts of gray areas. It's pretty clear now on subsequent review which one applies.
And Sabrina, I would just say too, from a personal perspective, since the dispute, the decade-long dispute as to what standard of review would be applied to a decision to move forward with a project utilizing either subsequent, supplemental, or addendum, having put that issue to rest and now knowing that it's a fair argument standard of review, I have seen that lead agencies are more likely to tear off of a previous document rather than to go back and err on the side of caution and have you do an entirely new EIR. So it has had a real impact and I think increased confidence to be able to utilize the analysis that was previously conducted and certified. So next slide, please. Another special situation is in the context of the significant effect exception to categorical exemptions, which I'm happy now is being referred to the unusual circumstances exception. As we talked about earlier, categorical exemptions are afforded substantial evidence standard of review, whether a project falls within a categorical exemption. However, when it came to whether an exception applied to utilization of that categorical exemption, courts were split on what standard of review applied to, in particular, one exception, which was called the significant effect. And that's at 15300.2c says significant effect. A categorical exemption shall not be used for an activity where there is a reasonable possibility that the activity will have a significant effect on the environment due to unusual circumstances. And so many courts interpreted that to mean that because the language was a reasonable possibility that would have a significant effect, that they ought to utilize the fair argument standard of review, whereas others afforded substantial evidence standard of review to the local agency's determination of whether that exception applied in the particular situation. The Berkeley Hillside Preservation versus City of Berkeley case from 2015 actually clarified this issue once and for all, but established a two-pronged part of the analysis. First, and I think really importantly, is what they found is that the language that you find at the end of that exception, which says due to unusual circumstances, is actually put there intentionally, and it had relevance, right? So the two-pronged analysis that they actually established for the agency was that the agency had to determine whether an unusual circumstance existed and then whether the unusual circumstance would result in a potentially significant environmental effect, thereby negating the categorical exemption. What courts then do is they look at the agency's determination and they afford substantial evidence standard of review to the agency's determination whether an unusual circumstance exists. In the Berkeley Hillside case, just to give it a little context, on a very steep slope in the hills of Berkeley, a proposal was brought forward for a 7,000 square foot home with a 3,000 square foot garage that could accommodate 10 cars on a very steep slope. Project opponents came in and argued that it was a very unusual circumstance, that the home itself was unusually large and out of scale with the surrounding neighborhood, that the hill was steep, that it was likely to result in landslides and other significant impacts, and therefore the categorical exemption should not apply. I think this boiled up because of the extreme nature of the home itself. The city, in making its determination whether unusual circumstances existed, looked at how many other homes of that size were located within the city on the hill. It made a factual determination. And so it does make sense that the courts decided that decision about whether an unusual circumstance exists is a factual determination to which the local agency should be afforded substantial evidence standard of review and deference. However, if the local agency does determine that an unusual circumstance exists, the courts apply a fair argument standard of review to the determination of whether that unusual circumstance has the possibility of resulting in significant environmental impacts. And so you sort of have this dual standard applied to that exception to a categorical exemption, where the first threshold question is afforded standard of review that is deferential. And then the second half is more deferential, or shall we say, in favor of somebody who would be challenging a project. Next slide, please. The final special situation that I would like to discuss is sustainable communities environmental assessments. SB 375, the Sustainable Communities and Climate Protection Act of 2008, was authored by Senator Darrell Steinberg. The objective of the bill, in no small measure, is to link planning with transportation and the development of housing in order to address climate change and climate change impacts associated with greenhouse gas emissions. And what it did is it created a SCEA, which is the acronym for the SEEA, which allowed streamlined CEQA review of projects that were considered to be transit priority projects, meaning that it was a majority residential development, rather dense, located in close proximity to quality transit. And interestingly, in the legislation itself, which you can look at Public Resources Code section 21155.2B7, the legislation actually identified specifically that the lead agency's decision to review and improve a transportation priority project with a sustainable communities environmental assessment shall be reviewed under the substantial evidence standard. This is important. I think as you think back to the slides at the beginning and ones that were covered by both Shannon and Sabrina, the purpose of CEQA historically is to err on the side of caution and to create an EIR and analyze a project pursuant to an EIR if it's likely to result in significant impacts to the environment, right? And the more, say, truncated environmental review of a NEGDEC is only afforded the fair argument standard of review. And if in fact it does not sustain that type of judicial scrutiny, then the locality is told it should have prepared an EIR. A SCEA, however, is clearly legislatively authorized to proceed and given substantial evidence standard of review. And I think this is important. The case that was recently decided, the Sacramentans for Fair Planning versus City of Sacramento, looked at the language in a de novo context and found that it was clearly the legislative intent to allow these projects to proceed under substantial evidence standard of review, and then gave substantial evidence standard of review to the local agency's determinations throughout the SCEA and the determinations that were reached therein. The ruling was pretty important, and it made clear that the deferential standard of review would be afforded to an agency's determination to prepare something less than an EIR and some sort of streamlined analysis when in the context of smart growth and good planning principles. And I think that wraps it up for my slides.
One last one for me. Next slide. So we'll talk briefly about the standards of review on appeal. It's widely cited that the Court of Appeal reviews cases de novo. But what that means is that the Court of Appeal reviews the same agency record and uses the same standard of review as the trial court. The appellate court's review is de novo with respect, in that respect that it doesn't defer to the trial court's ruling. It undertakes an independent review of the record, but it is still guided by the same standard of review that applies to the type of environmental review that's prepared and challenged and the type of error or non-compliance that's alleged. So it is in most respects an opportunity for a do-over of the trial court arguments with the same judicial scrutiny or posture applied to those arguments. And I think that's it for us. Q&A.
Great. Thank you so much. That was incredibly informative and wonky. I think we all know a lot more about standards of review than when we started at the top of this hour. We're now going to ask questions that have been submitted in the Q&A function. And the most upvoted question is about the definition of substantial evidence. So Shannon, would it be possible to pull up that slide, I think in your section in the beginning, that shows the definition of substantial evidence? Heidi Shuden asks, why the definition of substantial evidence includes the term fair argument. Help us sort this out. So I'm hoping Sabrina and Matt can help us sort out why the substantial evidence definition includes the term fair argument.
Well, that's a put you on the spot question.
Because CEQA is confusing.
Well, if you look at the definition in section 15384 of the guidelines, which of course is promulgated by OPR, and they're citing the authority that goes all the way back to no oil and running fence and Friends of B Street, so well back into the 70s and 80s, you know, when the concept of the fair argument and the courts were still sort of getting their arms wrapped around this idea that, you know, we default rather easily to the preparation of an EIR. And so my best assumption, without ever studying this issue in depth, is that the courts having used the term fair argument, it then needed to be woven into, you know, well, what does that mean for the substantial evidence standard? And since we're looking at, in the context of triggering an EIR, whether a fair argument has been made, I think it makes sense to sort of link it to this idea of how it relates to substantial evidence. You know, what is it that triggers a fair argument? It has to sort of, maybe the understanding was that it has to be in that definition so that we understand it when we see it. But I don't know, wish there was maybe some folks from OPR that could answer this question for us.
I can't say I was there when that was promulgated, unfortunately. But that is a great question, Heidi. And our next most upvoted question comes from Robert Sohagi and is more about the aesthetics impact, which we brought up in our first poll question. And you might want to read it in the Q&A. I'm going to read it out loud, especially for the folks on YouTube who can't see it, but it's quite lengthy. So Robert asked, isn't the issue of aesthetic impacts not so clear-cut? As one court recently explained, we do not believe that our legislature, in enacting CEQA, intended to require an EIR where the sole environmental impact is the aesthetic merit of a building in a highly developed area. And that's from McCann versus City of San Diego in 2021. He states, OPR also revised the aesthetics questions recently for urbanized areas to ask whether the project conflicts with applicable zoning or and other regulations governing scenic quality. So this is referring to the 2018 CEQA guidelines update that was initiated at OPR and then promulgated by the Natural Resources Agency. And while this does not have to do with standard of review, I think it's referring to that idea that if, you know, really the only evidence of a potential fair argument was that neighbor saying that there was potentially an aesthetic impact, you know, under current conditions, not during the time of the Protect Niles case, do you think that would still be enough to trigger an EIR?
Well, you know, I have tilted at the aesthetic impact windmill more times than I can count over my career, and I am hanging up my lance. But it, I think it's a good point that or maybe the point that Mr. Sohagi is making is that the aesthetic impact horse has sort of left the barn, right? Because if you look back at the definition of environment in the statute at 21060.5, it's the physical conditions that exist within the area that will be affected by a proposed project, including land, air, water, minerals, flora, fauna, noise, or objects of historic or aesthetic significance. So, you know, once upon a time, you could argue that the statute was intended to apply to things of aesthetic significance, you know, maybe epic views from a public vantage point. You might argue that they didn't intend it to boil down to the neighbors complaining that they don't like the look of a proposed development that's going in next to them. You know, what is the object of aesthetic importance that's being affected there? But Of course, over time, this issue has sort of morphed and developed a life of its own. And now we commonly understand the aesthetic environment, to be broader than this objects of aesthetic significance. So I'm not sure it's possible to bring that back into the barn, but I do still think there's a little bit of a split in the cases between, the first district has Bowman and I forget one other out of St. Helena, where they treated this issue of aesthetic and design consistency as, more of an issue on which they would be deferential to the agency. But then you have the line of cases out of the third, pocket protectors and Georgetown, where the strong opinions of neighbors about how a development would look, was afforded the substantial evidence stamp of approval. So I'm not really sure I'm not sure it's possible to rein that back in or to get much more predictability until the case law evolves maybe some more, or that there's some legislative solutions, such as there have been, sort of nibbling away at the types of projects for which you can assert an aesthetic issue. Because it is so highly subjective. And we made that argument in pocket protectors that, this boils down to a very subjective determination of whether there's an impact in this particular topic. And the court said, yep, it's subjective and it's still valid under CEQA. So we've made that argument many times without much success.
Sabrina, I'll just add that I think when you're talking about bringing the horse back into the barn, I tend to think that we're likely to see action from the legislature before we're going to see the courts resolve this matter.
Probably so.
There's been a lot of legislation in the recent years, focusing on objective standards as opposed to subjective standards. So I would bank on the legislature taking action sooner than later.
And in terms of existing legislation, you do have Public Resources Code 21099. I just passed an SB 743 that says aesthetics aren't required to be analyzed if you're within a half mile of major transit stop, existing or planned. So there have been some attempts by the legislature to address this aesthetics issue. All right, we are down to 1 minute left. So I think we will end our questions. And Shannon, if you could bring us to our last slide about additional resources that are available. And while you're doing that, we did receive a lot of questions about whether this recording and the PowerPoint presentation would be available afterwards. So yes, the recording will be on OPR's YouTube page. And then it will also be posted here on OPR's CEQA Getting Started webpage, which also contains links to the previous presentations in the CEQA 202 series and a lot of CEQA 101 overview material. So that's a great resource to check out. And OPR also has a variety of technical advisories on CEQA on our website as well. So please refer to those for more information about CEQA. And thank you so much for joining us today. Thank you to Shannon and Sabrina and Matt for an amazing presentation. We're so grateful to have you join us today.